Welcome, everyone. I am Gershon. I am the founder of Imperial Advisory. We are a fractional CFO firm. We work, we're based on Long Island, and we have a team of CFOs and senior financial executives. Most of our people have 30 to 40 years of experience, and we go into businesses that need help but don't necessarily need a full-time CFO. Sometimes with larger companies, we'll work for the CFO. Usually that's project-based, often around FP&A or M&A. And for smaller companies, we work for the CEO and we come in as a part-time CFO. As I mentioned a moment ago, we get involved in mergers and acquisitions. We touch on many parts of the business, really anything you'd expect the CFO to get involved in, we might get pulled into, whether it's strategy and kind of planning around that or helping execute initiatives. One of those things is mergers and acquisitions. So sometimes our clients come to us just for an acquisition. Sometimes they come to us, they're a regular client of ours. We do a bunch of things with them. We're their CFO, we're working for their CFO, and then we also help them with evaluating acquisitions. We also work on the sell side. But anyway, when it comes to acquisitions, one of the things we help clients with is digging into the company that they're buying and getting a real understanding of what it is that they're buying. And so that comes with understanding not just what has been going on until now, but what's likely to happen in the future. And there's obviously a lot of financial issues around that. There's also legal and HR issues around an acquisition. Give one example. Imagine you hire a company and all their employees are not legally allowed to work. So that if you're buying the company for the employees, that's a problem. If you're buying the company for the IP and you don't care about the people, maybe that's not a problem. But anyway, there's all sorts of issues, and we like to stay on top of those things and provide our clients and our network with continuing education to understand these things better. So it is our pleasure to have Doug Rowe back again to join us and teach us and educate us about what's going on in the space, particularly around people issues that relate to an acquisition. Doug is a partner at Sir Tillman Balin, which is one of the major law firms here on Long Island, and he's a great guy to know. I usually see him once a year at an event that's coming up this week, so hopefully I'll have the pleasure of seeing him again on Thursday night. Shout out for Friends of Karen. And without further ado, Doug, go ahead and introduce yourself and take it away.
Sure, Gershon. So yes, you will be seeing me on Thursday.
Awesome.
So thanks for the introduction.
Oh, can I interrupt for 1 second? I like to also welcome our team and all of our guests, but especially our team. So let me start with saying welcome, Brittany. Thank you for putting this all together. And welcome, Tom Amato, Stephanie, Dean, and at least one other person whose face I cannot see. It's great to have you all here. And now we'll try again. Doug, take it away.
Okay, sure. Doug Rowe, I head the Labor and Employment Law Practice Group at Sir Tillman Balin. And, when it comes to M&A, my M&A department will bring me in and to consult with me on labor and employment considerations in M&A transactions. I'm also brought in by other law firms for the same reason, because there are unique aspects of an M&A transaction involving labor and employment law, which I'm going to touch upon. When you put this out, Gershon, we talked about the people side of mergers and acquisitions, and I consider that aspect to be to involve HR considerations, which I'll touch upon. But there is also employment law issues in M&A, and I'm going to spend a substantial amount of time on that topic, because I've seen those issues from the litigation standpoint. Unfortunately, there are M&A transactions which can result in liability to the purchaser even though the purchaser may not have done anything wrong. It's called successor liability, but I'll get to that. So on the people side, that really refers to the critical human capital aspects of the process, managing employee emotions when there's an M&A transaction, cultural integration, talent retention, and effective communication. We have worked with consultants on M&A transactions who will be brought in to assist in the people side, and it's often an overlooked aspect of the M&A transaction. But the key components are cultural integration, which involves merging two distinct corporate cultures together. Talent assessment and retention, which beyond executive leadership is an assessment of the target company's talent. Employee communication, which is crucial to alleviate employee fears about layoffs, job security, and role changes. Compensation and benefits, harmonizing compensation structures, benefits, and performance evaluation process is a necessary step to ensure fairness and consistency, and organizational and process integration. So why does the people side matter? It matters because if it's not addressed, that can lead to a decline in business performance and the loss of significant transaction value. And many acquisitions fail to meet their objectives, with people issue being a major contributing factor, making a strong people strategy essential for success. Employee engagement, a focus on the people side helps maintain employee morale, trust, and engagement, which are vital to a smooth and successful integration. So when it comes to the people side, key strategies for success are early and ongoing HR involvement, strategic communication, seeking and ensuring employee support, and a focus on key talent. And from the legal side, we really don't directly get involved in those issues. But again, as I said before, we work with consultants who are involved in the HR aspects of the basically the people side of M&A. So again, if anybody has questions about that particular topic, please let me know at this point. But I'm going to then move on to the employment law considerations in M&A. So typically, when we get involved in M&A transactions, I'm sure everybody on this call is going to be involved in such transactions in the same way. It's typically either an asset sale or a stock sale, and it's important to understand that when there's an M&A transaction, if there's a stock sale, typically the buyer is going to step into the shoes of the seller and take on the liability that the seller had. In an asset sale, the buyer will try to avoid liability. They are buying only certain specific assets. They're not taking on they're not intending to take on the liability, and the hope is that in the asset purchase agreement, they'll be protected through indemnification language and warranties and representations. But that's not always the case. And for that reason, it's that much more important to do proper due diligence in employment law due diligence in M&A transactions. So as I said before, there's a concept in M&A, in employment law issues in M&A, of successor liability. Um, Typically, we see that in wage and hour cases or discrimination cases. If there's a pending case, the buyer can step into the shoes of the seller's liability. But even if there's not a pending case, if the seller didn't pay their employees properly, the the buyer can be liable for the unpaid wages of the seller. And we have seen from time to time where the potential liability to the buyer will exceed the value of the deal, because when it comes to unpaid wage cases, you're looking at the unpaid wages, you're looking at liquidated damages, you're looking at attorney's fees, and several other employment wage and hour claims that the buyer can be responsible for. So it's and when I said before, other law firms will bring us in, they'll bring us in to do the employment law due diligence that's required. So a buyer needs to know what they're buying, and they need to know whether the seller was paying their employees properly, was otherwise complying with the labor and employment laws, because otherwise they're stepping into the shoes. And I can't tell you how often I've heard a buyer say, well, I'm indemnified. Well, again, when it comes to a Department of Labor claim, for example, the Department of Labor is going to assert a claim against both the buyer and the seller. We're involved in a case right now where the buyer is a viable company. The seller is no longer in business. Their principals cannot be found, and the buyer is now facing, a pretty significant six-figure potential liability, merely because the seller didn't properly pay prevailing wages in connection with some public work jobs. And again, the buyer is saying, well, I'm indemnified, but there's nobody to seek indemnification from. So they're faced with this liability. We are arguing that they're not a successor under these circumstances, but I don't know how that case will end up. But at this point, it's just like it's just it's something to consider when it comes to these guys. It's something to consider in these type of cases.
Doug?
Yeah. Yes.
It's Dean. How are you? Nice to see you again.
Hey, Dean. Good to see you.
Quick question. And I'm not sure if you're going to get to it, but is there any protections that the buying company can take prior to an acquisition in order to mitigate some of these things, or is it mostly through due diligence?
Well, I think it's primarily through due diligence, but I don't know if rep and warranty insurance exists for those kind of issues. It might.
Got it.
So something to consider.
Okay, thanks.
Sure.
I would be concerned that from a lawyer standpoint, you're looking at risk that's monetized, but if you have an issue of this magnitude, it would seem to me it would sour the workforce when it becomes visible, and the liability to the acquirer goes beyond money in terms of the impact it has on the workforce.
What do you mean by that?
I mean that the morale of an organization could be further soured by this issue being openly litigated or discussed. And we often think, okay, I've got indemnity, and that may have a dollar impact, but when you open festering wounds, you sour the workforce, and that could be much more damaging than even the monetary issue.
Yeah, that is a consideration as well, because you know, if the buyer has hired the employees of the seller, and now the buyer is not willing to come to the table to take care of these employees who may not have been paid properly by the seller, you know, it definitely could have that people side impact, uh, you know, morale impact on the employees. Absolutely. So again, it's really, you know, the example I gave of the actual potential liability is just really a cautionary tale in these kind of cases. And it's just, again, something to be aware of. Again, more important, you almost have to do a full payroll audit if you want to do proper due diligence, and maybe not necessarily in every industry, but there are certain industries that are notorious for, you know, not properly paying wages, such as restaurants and hospitality, car washes. I'm trying to think of some of the businesses that we've been involved in where the successor liability issue will come up. And in those industries, you almost need to do a full payroll audit in order to be satisfied that there's been compliance with the wage and hour laws. And in the alternative, try to hold back enough money for this liability, you know, as part of the M&A transaction. But, you know, how much is sufficient to protect the buyer, you know, that's a function of the actual transaction and the potential liability.
But Doug,
Yes.
you mentioned earlier that sometimes the potential liability could be the entire transaction. So let's just say you have a business, it's a $2 million business, and they've been violating wage and hour laws, whatever it is, or, you know, in the dark gray for a long time, and there's $2 million of potential liability. So what happens then? We have this functioning business, it's making $500,000 a year in profit, and maybe something will catch up to them and maybe something won't. So how would you look at that? Is the business worth zero, or do we say there's a 30% chance someone will catch up with them? Or do you say, like, how would you approach that?
Yeah, I mean, look, I mean, it's evaluating the risk. I can tell you that when it comes to that hypothetical $2 million liability, you'd really have to analyze what the liability is based upon. The reason I say that is because, you know, from our experience, there are certain claims that are more readily able to settle for, you know, 10 or 20 cents on a dollar. So, you know, there were the law has since changed, but, you know, in the employment law bar, we've been involved on the management side of defending cases involving employees who manual workers who were paid on a biweekly basis, and the potential liability for that was basically 50% of the annual salary. So we were involved in cases where the potential liability was, you know, in the millions. We had one case where our client had over 1,000 employees, and the total payroll was 74 million in the last 6 years. So the potential damages were 37 million. And we ended up going to mediation on that case and settling the case for roughly $1 million. So, you know, you'd have to really evaluate the risk and look at, you know, how concerned you are with the potential liability. But, you know, that's the best way I can answer that. You know, and again, you know, because of the potential liability, you really have to try to hold enough, hold a sufficient amount. Maybe it's not a sufficient amount, but something significant enough back to support the any settlements.
We have a question in the chat.
Yep.
Doug, how early or late do you advise the buyer to interview the union, independent contractors of the company they're acquiring? Or contemplating how much staff and payroll is ideal for operations under new ownership.
Um, ha- I'm gonna look at that question.
Okay.
How early or late interview union independent contractors of the company report? I'm not sure what the question is because it says union and independent contractors. So, by the way, those are two other issues that are involved in the employment law considerations for M&A transactions. So, if a company is buying a union, if there's a buyer buying a union company, they have to address, what the collective bargaining looks like. They're going to end up in facing a situation where they're going to have to recognize the union. They don't necessarily have to adopt the collective bargaining agreement, but they have to consider negotiate what union negotiations will look like. They have to determine whether there's withdrawal liability, because in any asset sale it automatically if there's unfunded vested pension liability, a asset sale will trigger a withdrawal liability unless the parties address in their asset purchase agreement how to avoid the withdrawal liability. And the way that happens, by the way, is for a bond to be posted, for the seller to be the buyer to be primarily responsible, and the seller to be secondarily responsible. And there are other considerations that have to be taken into account in order to avoid withdrawal liability. So how soon should that be addressed? Very, very soon, up front. I mean, the union issues are certainly a big part of the transaction when the buyer is buying a union business. So that should be dealt with pretty early on in connection with the due diligence.
It could be like a segment of the business,
Yeah.
like let's say housekeeping, for example, when there's a purchase on hospitality, something like that.
Yeah. Yes, could be. Definitely. Then the question about independent contractors, that also should be addressed. These are questions that should be addressed early on. It's almost like it should be addressed side by side with the financial due diligence. That's the way we see it, because the potential liability for example, the question about independent contractors. If there's been a misclassification, most of the people on this call know that there is significant liability from a tax standpoint, from a workers' comp standpoint, unemployment insurance taxes, potential discrimination cases, potential unpaid overtime cases. So again, this is part of the due diligence, but part of the due diligence has to be determining whether independent contractors are properly classified. I hope that answered the question. Ezra? Oh, I don't know. You're on mute now.
Is it okay, Gershon? Or
Now we hear.
No, that's good. It was your question.
Yeah, so I mean, what we find many times is that the seller is very reluctant until the very end of the process of due diligence because of confidentiality, and they don't want to shake up, rumors within the organization that there's going to be new ownership until like it gets late in the game, and the attorneys don't like that because they need the time to understand and review the contracts. And
Right. So maybe the answer is to assure the seller that there will be confidentiality. I mean, I think, again, I can't stress the importance of addressing these issues early on. So
Does the
yes.
existence of a transaction, when it goes public, does it trigger scrutiny by labor agencies, governmental agencies? In your experience, does that in itself trigger reviews?
It could depend on, when word gets out that this transaction may take place, it's not automatic that there will be scrutiny by the labor agencies on the transaction, but it may result in a heightened awareness if there's going based on the ramifications of the transaction. So, for example, if there's going to be layoffs or there's going to be a relocation involving, 50 or 100 or more employees, in the area, the labor agencies in the area are going to want to know, how that's going to affect the employees on a local basis. And that could trigger the WARN Act notices under either state law, under New York state law or federal law. When it comes to due diligence, again, we've been involved in handling the due diligence, and what we'll also want to look at is the human resources policies and procedures, and look at the employment records belonging to the seller. So, I mean, in this day and age, I think one of the most important things, depending on the nature of the company, is to review a seller's I-9 forms, because there could be potential liability to the buyer if they're going to take on the employees, or there could actually be even liability for the to the buyer for the seller's failure to comply with the I-9 form laws. So, again, that's a consideration in the due diligence, to review all the employee records, employment related records. Part of the due diligence process is to review accrued paid time off. If employees have accrued paid time off and they join the buyer's company, they may be looking to the buyer to fulfill the obligation of the seller for accrued paid time off. So again, that should be part of the due diligence, and it should be addressed, from a financial standpoint, in the calculations of the purchase price. As part of due diligence, employment agreements should be reviewed. Non-competition and restrictive covenant agreements are important. Are they assignable? They should be assigned, but there's some case law involving whether non-compete agreements can be assigned in the absence of a right to assign language in the restrictive covenant agreement. So again, it's important as part of the employment law due diligence for the buyer to know what their employment contracts, the employment contracts state. As part of the employment law due diligence, the buyer should want to know what claims have been filed against the seller through over a certain period of time. Are there any pending claims? Are there any pending discrimination claims? Are there any pending Department of Labor audits? The buyer should want to know how the seller runs their business and whether they will inherit some of these claims.
Is that generally covered in the purchase agreement? Where the seller says there are no claims, or these are all the claims that are out there, or is it?
Yeah, I mean, it's usually in the disclosures and the reps and warranties, but again, it's one thing about them saying that there are, no claims pending, but you might want to know, what the claims history has been, what the workers' comp history has been, any health and safety complaints, any OSHA investigations. I mean, it's going to be a function of the nature of the business, but again, if they say there's no pending claims, that doesn't mean there haven't been claims that are no longer pending that the buyer should want to know about.
Got it.
Um, when it comes to employment law due diligence, there was Ezra, you mentioned before about independent contractors and whether they are properly classified. But one of the other important issues to know is whether employees were properly classified as exempt employees. So the mere fact that an employee is paid on a salary basis doesn't mean they're exempt from overtime. So, I can't tell you how many issues we've been involved in where there's been a misclassification of a non-exempt employee as an exempt employee. And if the buyer isn't aware of that misclassification, they could also, because of successor liability, step into the shoes of the seller and be liable for unpaid wages because of that misclassification.
Doug, would the impact differ if it's an asset sale or a stock purchase?
No, the impact is the same. There's successor liability in an asset sale. So again, as part of the due diligence, make sure you understand whether employees are properly classified as exempt versus non-exempt.
Do you have to, when we talk about an asset sale, is that only if you buy the entire business? Or can you just buy something small and still take on all sorts of, let's say you buy a division or take over something?
Yeah, you could just buy a portion of some of the assets or a division.
How about if you buy a client list from a business? Does that, I'll give you an example. We bought IP this year, right? We have a company, I'll give a plug, CFO for Vets. Imperial Advisory is an investor in CFO for Vets. It's a veteran company that served, it's a company that provides CFO services for veteran-owned companies. So we bought the IP and then we restructured and whatever. We made a bunch of changes. But let's say we bought the IP and we bought the client list, and now we're servicing those clients. Now, there was only one employee who was the owner in the past, so it wouldn't be relevant. But let's say he had 5 employees and he sold us, and he didn't pay the people. Let's say he didn't pay his people properly, and he sold us his employee list and the IP. So now we're operating a company with that name, using that IP, working with the same. I mean, he sold us rather the client list, and the employees disappeared. Could those employees come now and sue us because we're the new company?
They could take the position that you're a successor. I mean, I don't know what else was in the company. The IP and the client list may be the only assets of the company.
Right.
I mean, I don't, what else? It could be a couple of desks, a computer. I mean, that's sort of, de minimis. The actual company is really the client list and the IP. So I would say that would probably constitute an asset sale sufficient to create successor liability.
All right. Well, there were no employees, so we're good.
Not that the seller did anything wrong, of course.
Correct. And not that the seller did anything wrong, and also there were no employees, so
Right.
whatever. It's all hypothetical.
Doug, do you think the issues that arise primarily from federal legislation, or do state and local regulations have an equally impactful risk?
Federal and state. For example, under federal and state, both federal and New York State at least have, overtime laws. So if employees were not paid proper overtime, the claim could be brought under federal and state. There are some laws in New York State that are unique to New York State. For example, there's a wage notice and a wage statement form requirement. That's a state law, not a federal law. But if the seller hasn't complied with those state laws, then there's going to be successor liability for those, that liability. So, it's both. It doesn't matter whether it's federal or state law.
Do the state laws vary enough such that an outsider acquiring a business for the first time in New York State, it becomes a barrier to entry or something that must be concerned? If you're operating in New York, that's one thing. But if I'm a Tennessee company and I decide I want to penetrate the market in New York, it becomes, I would think it becomes a real issue. Do I really want to take on certain burdens that are not prevalent in the rest of my business?
I don't know how to answer that. Obviously, it's going to be a function of, when it comes to an out-of-state company buying a New York State company, they're going to need, it's almost like a heightened awareness of the New York employment laws. And, it's going to require, really, paying attention to New York State compliance, by the seller. So, I mean, we've had clients, by the way, that have fallen into that scenario because they were not aware, for example, they were not aware of that law that required them to pay manual workers on a weekly basis. They were an Alabama company that bought a New York company, and they just continued to pay the employees on a biweekly basis, and they were faced with significant liability because they were not aware of that issue. So again, just shows the importance of due diligence.
Can I just jump in for a second to
Sure.
address what Tom was saying? Obviously, I'm not talking from a legal perspective, but I consider what states I hire people in, because there's some states that are just really annoying to be involved in. So it definitely, and I know I've had these conversations with other people, it's definitely a consideration for a business owner. It might be worth investing in the diligence and dealing with it if there's enough to gain, but all else being equal, being in a place where it's difficult to do business will make people not want to do that kind of business.
I mean, you're right. I can't tell you how many clients have said to me, it doesn't make sense for me to be in business anymore because of these New York State laws, for example. So, and then California is even stricter than New York. So yeah, I mean, it's a consideration.
If I wasn't from New York, I probably wouldn't want to do business here. I'm just already anchored to the New York mentality. So California is really bad, but other states, I'm used to New York.
Right.
Well, when you're there, Gershon, the barriers keep other people out.
Right.
Yeah.
But Pennsylvania's cool, Tom. We should come hang out with you more.
I touched upon employees versus independent contractors and misclassification there. It's really an interesting issue because, right now, it's like the law seems to be changing, every few years. So under the Biden administration, basically there was almost a presumption that everybody was an employee, with limited exceptions. Now under the Trump administration, it's loosened up, and it's still difficult to properly advise a client on whether the seller has properly classified individuals as independent contractors, but it still needs to be scrutinized. Actually, I met somebody the other day, if anybody cares to know this, but has actually started a company that is involved in basically giving doing an analysis on whether a person is properly classified as an independent contractor. And they have a pretty sophisticated, software program to reach this conclusion. I don't know how they do it, but I thought it was pretty interesting to the concept. And again, I think they're in danger of really giving legal advice and having, their users rely on it. But I just wanted to mention that if anybody's interested, I can introduce you to this software company. When it comes to due diligence, I mentioned before about having to do a full payroll audit. A buyer is going to want to know what the time tracking system used by the seller was. Do they have a time clock? Did the time clock round off time? Did the time clock include a meal period or not? All these issues, all these factors go to the issue of whether the seller has been in compliance with the wage and hour laws. And again, to know about the time tracking system of the seller and to actually make it part of the due diligence is an important factor. I mentioned before, again, as part of the due diligence, reviewing collective bargaining agreements and potential any grievances, pending grievances, prior grievances. That goes to the issue of, the employee morale, whether there have been any substantive issues or claims, whether there have been terminations, and again, any other factors that may be triggered by the M&A transactions arising out of the collective bargaining agreement. I mentioned withdrawal liability, again, just to be aware of when it comes to buying a union business. I touched upon WARN Act obligations. Obviously, as part of the due diligence, a buyer is going to want to review the employee compensation and benefit plans to see, first of all, whether there's been compliance. That's sort of could be part of the financial due diligence as well, but it's important to review, employee comp and benefit plans as well as part of the due diligence. When it comes to successor liability, we came across an issue a few years ago. This is interesting. I'm curious as to whether you've seen this before, but there's a risk that a buyer could step into the shoes of the seller's unemployment insurance experience rating. So you could have a buyer that never had any claims, but I've seen this before, that the buyer will actually step into the shoes of the seller's rating, and which will trigger a significant increase in the buyer's rating. We had this issue, and what was interesting is that the once that happened, the buyer took the position that and it resulted in a significant increase in dollars to the buyer, and the buyer took the position that this was a violation of the tax representation and warranty section, and they basically forced as part of the negotiations, forced the seller to foot the bill of that increased unemployment insurance experience rating after the M&A transaction. So again, it's something to be aware of I'm just bringing it up because it's come up.
And they prevailed. They got the seller to pay.
You know what? The buyer didn't want to, the seller didn't want to litigate. So, they
Or
basically,
selling.
yeah, there was some letter writing back and forth, and they just gave up on it.
Are the state agencies aggressive, looking for these opportunities to increase revenue?
Yes, of course. Of course. I mean, the workers' comp board and the unemployment insurance division are being very aggressive these days.
Now, Doug, was that a case of an asset sale or a stock purchase? Like, did
That
you
was in
buy
the case. That was in the case of an asset sale.
so you buy someone's client list and therefore you should have their workers' comp experience? How does that track?
Um, I'm not sure in the case I described how the unemployment insurance
No, but
uh
Gershon, why are
do
you presuming they only acquired the customer list? I mean, you can do an asset deal, which is basically the same as a stock deal, except that you have defined it as being assets and liabilities
Fair.
being assumed. So if you take on all the people, the state's going to presume you've got that liability going forward, and their experience is going to transfer.
Okay, so my question should be more precise, but in your case, Tom, I agree. If they just bought a client list, then I wouldn't necessarily agree. So I'm not agree or disagree, but just then it makes sense. In your case, they're basically buying that business, so who cares how they structure it? Of course, they're going to have the same. They have the same people, the same policies, the same way of doing business. They're going to have the same risk, but not necessarily is that always what goes on. Like sometimes you're just buying contracts and you're not necessarily using the same people and that kind of
Yeah,
guess.
I don't know how the unemployment insurance division actually found out that there was a transaction, and they tried to pin it on the experience rating on the buyer. I don't know how that came about, but they did somehow.
Okay.
Yep. Um,
You know what? Let me just mention one quick thing about that. We had a client who at one point was looking to get into business. It was in a heavily, business with significant workers' comp expense. And they were thinking of buying a company rather than starting from scratch. And this is the other direction because they wanted the workers' comp experience of the seller.
yeah,
In the end, they didn't buy it because it was family drama and whatever. They just
Right.
started their own competing company. Not
right.
completely competing, whatever, their own company. But I don't know if they had legal advice and all that over there, but that was, again, it was the other perspective that they were
Yeah, I
expecting
don't
it
know.
to
Were they
transfer.
going to shut down their company and just take over the company they purchased, and then just try to run with that workers' comp experience?
Actually, they ended up starting their company. I don't know. At one point, they were thinking of buying it before their company existed, and then I think they were looking at it again later, once their company did exist. I don't know if they were going to shut it down or roll it in, but I'm not sure. Doug, we have about 5 more minutes. I know that we're
Yeah.
coming toward the end. You got fun stuff to do after
Yeah, but I have
this,
to go
and
to court on another wage and hour case. I have to be in court at a virtual conference on a wage and hour case in 7 minutes.
okay. So let's. I guess we should aim to end in a couple of minutes. Leave a few
Okay.
minutes for Q&A.
Yeah,
As
I'm basically done. I think just like the takeaway here is really to see what's involved in employment law due diligence on M&A transactions, and really to line it up next to the financial side, because it's that important, especially where you have this concept of successor liability. And just remember that that the reps and warranties section and the disclosure of claims section is not necessary. It's not necessarily going to protect the buyer. from successor liability. So something to be aware of. And again, almost a random payroll audit may be necessary depending on the industry. And then if you have any questions, call Doug Rowe.
Yes. Any questions? Call Doug Rowe. That's what we do. All right, we have 1 or 2 questions in the chat. Anyone else has anything, pop in. I'm gonna put up the poll. Let's see. I'll read it out and then Doug, you can address
Sure.
it. Is there some terminology or agreement the acquiring company can stipulate on the PSA to place the onus on the seller for back taxes, overtime, or independent contractors, I guess misclassified independent contractors, strictly on the seller, similar to the way prior sales tax audits claims will not be associated with the new owners?
Well, yeah, I mean, the answer, Ezra, is that's the indemnification agreement. But that's not going to stop the Department of Labor or the IRS to come after the buyer. So the indemnification language is fine. That's the kind of provision that the buyer would want in the agreement. But again, using my example before of the pending case, if the seller is out of business, then what value is that indemnification language going to have?
I see that. What about a different EIN number and a different entity where you're removing yourself from any prior liabilities for, let's say, overtime claims? You know, would that be
To have
sufficient?
different EIN number is not going to accomplish anything. If the company if there's still a viable business with employees, then any lawsuit can be brought against, or the Department of Labor can audit the buyer.
And Doug, is it fair to say differently that the issue follows the employee, not necessarily EIN numbers or anything else, right?
That's right. That's right. I mean, the employment laws, don't recognize the corporate formalities, different entity, there's no protection like that. It's basically, it's the laws are intended to protect the employees, not the employer.
Welcome to New York.
Sure.
All right.
Any other questions? I hope this helped.
Yes,
At least something to consider in your M&A transactions.
thank you very much. Thank you for joining us. Thank you, everyone, all of our guests, all of our team members. Thank you, Doug. If people can take a minute to fill out the survey, that would be helpful as well.
Okay.
3 quick questions. Doug, good luck with your
Yep.
with your judge.
Thank you. Thank you.
And
Thank you, Doug.
we
Sure.
have some information from Doug, some PowerPoint relating to this. So if anyone's interested, we'll send that to you, or maybe Brittany will send it to everyone. And hope to see you all again soon. Thank you all.
Thank you.
All right.